Hello and welcome to tutorial key point videos for tutorial number 7. This session we did a lot of practical things. We looked at problem questions relating to social policy and also to competition law. And it's an important point to make at this stage in the course. As you look forward now to the exams, give yourself every opportunity to solve problem questions, also to think about how you would respond to an essay type question by doing the research now, looking at past exam papers. They're available for you on Elite. You'll find other problem questions throughout the manuals. Use those as opportunities to practice that problem solving, which is such an important part of the exam and also of the work of a lawyer. As well as the practical sides, obviously we looked at TMA 05 and I made a few remarks about how that had gone, and what I stressed again was logical, reasoned answers, using cases where appropriate. And sometimes it can be easy to think, oh, well, we'll just sort of garnish an answer with a few names of cases. It's actually engagement in those cases and the arguments involved that is central. So one of the best ways of getting used to do that is to spend some time reading full law reports and seeing how the judges argued. The substantive area that we looked at in detail was competition law. Again, quite an important area of EU law for this course and for its assessment. We looked at the rationale behind competition law. It's making sure that it's a level playing field, that the market isn't actually made more inefficient by powerful players or groups getting together to fix the market for their own advantages. And the two key articles, do look at them in detail, there's quite a bit in the manuals on them, Article 101 and Article 102. Article 101 is about where more than one, although that can actually include a subsidiary of a larger company, more than one organisation or body cooperate together. The wording is quite important. The business arrangements that it's covered don't restrict themselves to very narrow definitions. So it can be decisions by organisations such as trading groups. It can be actions by different companies working together, or it could be concerted practices. It very clearly steers clear of getting involved in legal definitions of what an organisation is. But the first thing is that the Commission needs to show that it is some kind of practice that involves more than one body. Secondly, that may affect trade. The Commission does not have to prove that trade itself actually was affected, but that the arrangement was such that it could affect trade. And thirdly, the arrangement has to be either the object or the effect has to be restriction of competition. So again, the Commission doesn't have to prove that you deliberately set to restrict competition. It may be just that the effect of the arrangement could affect. Look at the consequences. These are prohibited. And what can happen is that if a contract is negotiated, although it doesn't have to be in the form of a contract, it can be a mere arrangement, a verbal agreement. It doesn't have to fit any of the legal definitions that we're used to. If it falls foul of that obligation is just struck out, of no legal effect. So it can have big implications for arrangements, because the rest of the contract will stand if you're applying it to English contract law. Prohibited. But sometimes these arrangements actually can work to the benefit of consumers, and there are circumstances in which the Commission can make those practices allowable. So look at the block exemptions that are described in the manual. Article 102 deals with a different scenario. Whereas Article 101 was about a number of different bodies, this is about the one entity. And it's about abuse of a dominant position. Two things have to be shown. Firstly, that there is a dominant position, and look at the definitions in the manual about relevant product market, the relevant geographic market, and market power. In the early days, it was just thought of in terms of, a certain percentage of the market showed you were in a dominant position. It's become more sophisticated than that. Do have a look at the cases here as they refine this idea of a dominant position. It's very easy, and I've seen it many times in exams, for students to prove the dominance and forget the other element, which there has to be an abuse of that dominant position. And abuse, again, is about using the position that they're in to gain an unacceptable advantage over competitors, thereby affecting competition. So competition law, very important, but also very straightforward. The three things for Article 101, the two things for Article 102. On to TMA 06. Again, this is the application, this time in reverse order, of Article 102 and Article 101. Explain, apply, and do bring in the arguments from the cases that are involved. So for Article 102, I would expect to be seeing from you some discussion of the United Brands case, the Continental Can case, Ugin, and ASCO. The second part on Article 101, less case-based, but you need to explain and apply the principles. Well, thank you, and I look forward to our next tutorial video in September.